Good evening, everybody, and welcome to another in the series of uh, CLE presentations that's offered by New York Law School's Alternative Dispute Resolution Program. My name is Peter Phillips, and I'm the director of the program, and I'm very, very proud of the fact that we're able to offer to you tonight really one of the most prominent and accomplished members of our community, Barry Appleton. Uh, he is an intellect of some substantial uh, accomplishment, and I'm very, very honored that was kind enough to set aside time to join us today. Before I hand it over to Barry, I just want to thank everybody for all their help and participation during our academic year. It ends next month, and our final program of this series will be uh, our annual program with the AAA and Jeff Zano on cutting edge topics of arbitration. Uh, that's one that we go ahead and offer at the law school. And it's always an opportunity for people not only to learn a lot from our expert panel and from Jeff Zano's terrific moderation, but we get to see each other again. And for those of you, many of you who come every year, I think you can attest that we offer about the best bottled water and pretzels that you can really get. So I encourage everybody to come on down to the law school. It's going to be live streamed for those of you who, like Barry, live in Toronto. But for those of you who are around the New York area, come on down. Everybody is going to get a notice of the event. That's on the 21st of April. So that said, Barry Appleton, I'm eager to know what I need to know, but I'm even more eager to know what I don't need to know. It's up to you.
Well, thank you so much for having me today. I am delighted to be able to join you and to try and talk a little bit about one of the transformations that really affect what we do in dispute resolution for mediation, for arbitration, for all of the aspects that deal with dispute settlements. The world has profoundly changed, and it's not just about AI, but there are things that are related to AI. And it's my privilege to be able to come here on behalf of the Alternative Dispute Resolution Skills Program at the New York Law School and talk about the nature of the changes. And so let me tell you that most of the time when people talk about these things, and I have the privilege of running a program for the American Bar Association, and that program's called TechCred. And TechCred, I'm the faculty director. It's run from the New York Law School. We're the credentialing agency for the American Bar Association's International Law Section. And TechCred is the first program of its kind in the world to be able to help the alternative dispute resolution community deal with the real nitty-gritty that you need to understand about the world of AI. And so, but so many of the issues are apocryphal. There are things on the side that are not really the important things. And the things that are very important, we often don't get to talk about. So my goal today is to focus on what ADR professionals need to know and to help you to understand what you do not need to know. This program is completely up to date to what's going on this week. I've included stories that are from today's press. I've included a new paper on the issues that we're going to talk about that came out a week and a half ago. I wrote one of them out. It's for the Austrian International Arbitration Yearbook. There's a variety of things. This is global in scope, because one of the things we're going to find out is that often the issues that we want to deal with cross borders, and those crossing of the borders impact some of the decisions we need to deal with in arbitration. So even when we're in a solely and utterly domestic mediation and domestic arbitration, there could be connecting factors and issues that require us to know something a little bit more than what we've done before. So that's my goal, is to take the next 75 minutes, including questions, and walk you through what you need to know, what you need to focus on, what you do not need to worry about, and to see if we can get a little bit of better focused understanding in such an important new area. And
By the
again,
way, I'm sorry, Barry, I did forget to mention you since you mentioned questions. It's been our process in the past that I'd like to continue. That if people have questions, go ahead and throw them in the chat field, okay? I will monitor the chat field so that Barry can continue. And when we have time for questions, I'll field what you have posted. I'll take that up to Barry. Excuse me. Go on ahead, Barry.
oh, great. Well, thank you, Peter. And again, I want to thank you all for such a wonderful opportunity to be able to talk about this. Um, let's start in. Just tell you that what we're going to do is talk a little bit about what AI can do and can't do. We'll talk about the effect of the regulatory landscape because that has a big impact on us. Especially as lawyers, we're being regulated in AI, both as users, as thinkers, as arbitrators and participants. I'm going to introduce to you how AI comes into the hearing room. And that will also include a discussion about a new AAA product, which has had a lot of buzz. And I want to explain to you how it works, what it can do, what it can't do. We're then going to talk about data privacy and something I call the Lex Data. We all know the Lex Arbitry if we're in arbitration. Well, there's another thing we need to think about, and it's the Lex Data. And it's the emerging law of data in arbitral proceedings. I'm going to take you through that a little bit. I'm going to give you a case study. And this is a study where we see a case where the arbitrators got it wrong. And so that you will see from what they've done so that you don't get it wrong. I'm then going to take you through the Lex Data in international arbitration, which I sometimes call the Lex Arbitration, the Lex AI, the framework to deal with that. Then we're going to look at some of the things that everybody asks me about, and I think we need to know: hallucinations and responsibility. And that's very important because we have professional and ethical standards, and the courts are now weighing in. And I will take you through the first case that was important on that, Mad and Avianca, but I'll take you through the most recent ones, including one that's quite recent, that just came out about 4 weeks ago. And the courts are now making it very clear that they don't like it if you don't check things, and professionally, it's one of our obligations as well. We'll talk about that. And that, of course, takes us to talking about ethics. So we're going to really focus in on ABA Opinion 512. I'll talk about procedural fairness, very important in arbitration and in mediation. And then we'll think about the concept of equality of arms and what that means in the world of AI. Then we'll go to questions, and I'll have some key takeaways. So that's the game plan. Let me tell you a little bit about TechCred. So TechCred is something I get to do. I come from the Center for International Law. So that's another center at the New York Law School, but I teach international arbitration, and I do international arbitration. I'm a fellow of the Chartered Institute. I spend my life thinking about international arbitration a lot. So TechCred is an ABA-sponsored micro-credential and digital disputes competency. And it's made specifically for the arbitration community, for the mediation community, for neutrals. It's not about learning how to do prompts. It doesn't help you on how you use ChatGPT or Claude. It helps you with how you use judgment, how you use your ethical obligations, how you can focus professional responsibility. And then we need to understand how evidence has been changed in the nature of data streams and AI. So we're going to talk about that. We're going to talk about data privacy. We're going to talk about a framework that can give you as a professional in the ADR community the ability to govern AI in cases, in awards, and approaches. And so in the TechCred program, we do that in 3 half-day sessions. They're live, interactive, but done online, so we can get people from all over. They don't have to come to us in New York. We had our last session in the fall of 2025. We graduated out 55 people with the TechCred designation. We'll be doing our next one sometime in the summer of 2026. And we had a large number of institutions, including the AAA and JAMS and a number of arbitration associations, the one in Vienna, VIAC, the one in Miami, MIAS, the California Arbitration Society, the Silicon Valley Arbitrators and Mediators. Large numbers of groups have been sponsoring Arbitral Women. They've been seeing the value in having as many people who can demonstrate competency in this world, because our clients are starting to expect it. Not only are our clients starting to expect it, but the institutions are starting to expect it, that if you're going to do an arbitration, you need to understand the rules and designate, show everybody that you have a designation, an ability to demonstrate that you understand it. So what we do in the TechCred program is talk about professional responsibility in AI and evidence and hallucination. We actually do case studies and little projects. We talk about data privacy. We talk about what you do if in fact you've been hacked and how you deal with cybersecurity. We talk about the Lex Data and the Lex AI. And then we talk about institutional rules and how we might put that together into a procedural order, a PO1. So that is a more in-depth program. I'm going to give you some of the highlights of that today. My goal is to try to really give you up-to-date knowledge so that you can have the right questions, the right focus, and the right process, and you can start to evaluate how procedural fairness and ethical obligations fit into what we do in ADR. That is really my objective for today. And just so that you all know, we have a blog called the TechCred blog. If you look in that gold box at the bottom, it's free. You can connect in to the TechCred Substack, and it brings up-to-date types of issues so that you can see what's going on. That's really what we're going to do, is give you that type of information so that you can keep up to date and see what's there. You get real-time analysis, case law updates, regulatory alerts, practitioner interviews, institutional roundups. It's designed to make it easier for the ADR community, and of course, it's free. And I just put on one of the slides some of the most recent little things, but you just go on the blog and you can see all of these things. And yes, I know that Professor Phillips will tell you at the end that the slides will be able to be made available after the presentation as part of our follow-up. So, because there aren't that many slides, but they're very detailed just to make your life a little bit easier. Okay, let's focus in on today. I want to focus in fundamentally on 3 pillars, okay? There are 3 key things I want you to understand about AI. Because AI changes law's form, but it doesn't change its purpose. So we have to keep doing what we do. We know what we do as professionals in alternative dispute resolution, but the way we do it changes because of the impact of AI. So the 3 pillars are going to be as follows. The first, authenticity. Can we trust what we see? AI generates all types of material, but it doesn't verify. Humans have to not only verify, the human aspect is to certify. So what we want to do when we're in that process, especially if we are the decision maker, but even if we're the counsel, we need to show the humans have certified. In other words, if AI, the A is artificial, the I is intelligence, the intelligence part continues, even if the A is involved. And the buck stops all the time with the person. That's the second pillar, accountability. Who is responsible? Humans. The buck stops with the professional. It doesn't come from the algorithm. It doesn't come from the computer program. It's got to be the person. It's got to be the professional. That's what we're called to the bar. It's a calling. It is not the impact of computer code. It is our guarantee of professional responsibility. And the third pillar is enforceability. Will the award, if this is especially important obviously for arbitration rather than for mediation, but in mediation we have a Singapore Convention, so we also have enforcement. Will the award stand? And will there be some impact because of AI that impairs enforcement? Obviously, we want to have decisions that are enforceable. Otherwise, what's the point of doing this? And visible fairness, transparency, is the bedrock of legitimacy. So what I try to focus in on this is the human responsibility, the need for humans to take responsibility across the way. In essence, you might call that agency, that the humans have to do that. You need to confirm that it's authentic. You need to take accountability, because that's going to lead us to enforceability. And that's because the process of AI is predictive. AI doesn't understand anything. AI is about pattern recognition. It is not about knowledge. AI systems don't know anything. Even if they talk to you in a nice voice and they're polite, there's no person there, there's no knowledge there. They can't make moral judgments. They are simply dealing with patterns after patterns. And therefore, AI predicts, but it can never comprehend. Our judgment as humans is not optional. It is the irreplaceable thing. The accountability and authenticity and enforceability come from the human. And the human has to be there, has to supervise what's there, and has to be at the beginning and at the end, the alpha and the omega. So, that was a lot. Let's see how the laws come, because we have a legislative landscape, a regulatory landscape. And here in New York, we actually are now getting into the act. So let me just start by saying that in the United States, we have no national AI legislation. In Europe, they have a regional AI Act, the EU AI Act, and it is beautifully organized. We're going to talk about that in a minute. But in the United States, we exist in what we might call a regulatory sandbox. You get to play, you get to experiment, but there's not any rules, or the rules are so minimal. So because of that, 20 states have different types of AI regulation. And sometimes it's even in the city. In the city of New York, we have AI regulations with respect to employment discrimination. But we now, as of last December, the governor signed the RAISE Act. And it comes into force on January the 1st, 2027. And it creates AI legislation for the state of New York. And since this is a New York CLE program, I thought it would be useful to make sure that you understand that it exists. But it's not going to affect you in the same way, because unless you are Google or Meta or Amazon, they're all affected. But it does affect our ability to start thinking about transparency and disclosure, which is why I'm talking about it. Because AI evidentiary disclosure standards are starting to evolve, and the RAISE Act will show us that you can get that information, and therefore it's going to create subsidiary legal obligations for us. So it's not that we're going to be regulated directly by the RAISE Act, is that the RAISE Act, because it's going to create a disclosure obligation on the big AI platforms, you as a user are going to have more information, and you're going to be required to be able to disclose that. And we're going to talk about that in a minute. I just wanted to flag that the soft law era has ended and that compliance is coming together. Now in California, they were off on all of this first, and already in this year, they have, I call it still SB 53, they call it the TFAIA. It is a specific act that creates an AI safety framework. It's mandatory in California. New York, we don't have it yet. Remember, we're going to be a year away. But in California, the AI developers have to disclose risk assessments. In other words, they have to give you transparency about the nature of AI that they use. And then you as a user may very well have to disclose that as well. And that would happen because it's going to be in procedural order 1 if you are counsel. And if you're an arbitrator, you're going to have duties where you're going to have to disclose. And we're going to talk about that in today's discussion. I simply want to flag to you that the time of having no regulation is basically over, and that human oversight and documentation is now going to be the law in the United States, where it has already been in the EU. In the EU, they have an AI Act. The AI Act deals with risk basis, and I'm going to walk you through those in a slide specifically. But arbitration is considered within the high-risk activities, or even some areas in the prohibited activities. And those of us that know about international arbitration and enforcement know that if the lex arbitri has mandatory provisions, and if those mandatory provisions say that it is a violation of public policy to engage in a certain activity, then all of a sudden the arbitration awards enforceability in Europe is going to be at risk. Now, what the EU AI Act is going to require are things called conformity assessments and audit trails. It's going to give you disclosure. I call it algorithmic transparency. So you understand how the AI is using the patterns, how the AI is making its decision. If you use Jus Mundi, they use an AI model, an LLM model called Mistral. Mistral is a French model. So it has a window that you can go to that explains how it's coming up with its decision. But if you use Claude, or if you use Gemini, or if you use ChatGPT or Microsoft Copilot, we don't have that in the United States because US law doesn't require that. And what we want to avoid is the situation that happened in Deutsche Bank and Latinier. And the Deutsche Bank case, I'm going to come to this when we talk about the cases, but I might as well tell you now, it's a New York case. It was decided last month. And in this case, there were 23 AI fabricated citations. It involved a mortgage issue. And there were 23 hallucinations. They all looked good. They looked plausible. But they weren't humanly checked. That enforceability, that responsibility, the buck stopping with the human wasn't done. And so the lawyers were sanctioned by the court. I got a report today of a decision in Ontario, in Canada. Same thing. The courts are starting to say it is not acceptable now for individual lawyers or arbitrators to rely on materials that they haven't checked and that they haven't disclosed. So the period where you could use AI without disclosure is really risky to not possible. And as we talk about the EU AI Act, I believe you're going to see this rights-based focus, this risk-based analysis, as foundationally what you're going to see in state laws in the United States, and eventually what will be a US approach too. But you're going to see this without a doubt within the next year in Canada, in Mexico. It looks like it's going to happen very shortly in the UK. So if you have an international aspect, if you have a party from one of those states, so anywhere in the EU or in the UK or in Canada or in Mexico or in Brazil, they have it as well, you're going to find that there's going to be obligations that you have to follow as a participant. And that's what we're going to talk about. But
okay, before we move
Sure.
on to the next slide, Barry, if I can interrupt you,
Sure.
we do have some codes that we have to give. The first one is TechCred. Our first code word is TechCred, TECHCRED. Please make a note of that. And when the program is finished, bring up the form that was emailed to you and insert that phrase into there. Barry, go ahead. I'm sorry to
Well,
get
no.
in your
Well,
way.
Professor Phillips, thank you for the public service announcement. And I know we're going to need to
There
do
you
more.
go.
Right. So all I want to tell you is that the world is changing and the law is slowly changing with it, and we need to get there. And so what we want to understand then is the first big development, which is about AI arriving in the hearing room in arbitration. And the key place for that is the AAA. The AAA and the ICDR have two AI tools that are now live. The first one was launched in the fall. The second one was launched just a few days ago on March the 4th. And so they have an AI arbitrator, and this is for construction arbitration only, document only construction cases. But here, everything goes in and AI leads the way. And now they have a resolution simulator. It's basically like mediation. Single party, non-binding strategic preview. And it sort of tells you, are you going to lose your case in advance? Or are you going to win? So that's the newest thing that just came in. But in order to be able to do this, all the parties have to confirm that the AI has correctly summarized their arguments. So one of the party could say, no, it hasn't, and then that process ends. The AI is going to draft the award. Now, the award has to be reviewed and edited and signed by a human. But remember, AI can't make judgments. It can't deal with credibility. It can't figure those things out. So what's happened is that there's been a very mixed reception. Some people love the idea. They say, this is great. It's going to make it much less expensive. We're going to be able to make arbitration low cost. And now we're going to be able to make mediation low cost. But you'll see in the CLE materials, we put an article from Law 360, I believe it was from yesterday, where a number of firms had commentators that came out, Herbert Smith and Mayor Brown, talking about their concerns. But to the AAA, they say human authority is preserved because an arbitrator has to sign it, and that the responsibility remains human. And that is, of course, only correct as to A, the role that the human has taken, and B, if the human understands what the AI is doing. Because the AI is looking at patterns, it's not making other judgments. And do you know how it's making its decision? We have the same thing. If you have an expert who provides materials to you, and the expert uses AI, how much is that is the expert, and how much of that is the AI? And so institutional rules are evolving, and we need to think about that. And what I'm going to suggest to you as we go along is that you need to think about this in your appointment letters, in institutional guidelines, and in your procedural orders. And that last year, if you asked me, I'd say people would not expect disclosure. Disclosure would be an impact on the attorney work product. But today, disclosure is expected. And so we need to look at that, and I'm going to walk you through some of the elements of what you might want to think about in your PO1. Because that is going to be the issue, because we want to have something that's enforceable. That's our goal. Now, I want to turn to how data privacy fits in, and that's going to take us to what I call the Lex Data. This is a new set of normative rules, and it's crystallizing around data in international disputes, but even our domestic disputes. If you have a party who's from somewhere else, or you have counsel from somewhere else, or an institution that's global that may have people into other places, or experts that participate, you can have an international aspect to your case, because you can have data subjects in more than one venue, more than one jurisdiction, and that can trigger this. So Lex Data is a body of rules, and it's drawn from maybe international treaties, but mostly from national privacy laws, and a little bit from arbitral precedent. And it's going to govern how data is produced and protected and processed in an international dispute. I think about it a little bit like the Lex Mercatoria, the international law of commerce that became eventually the rules used by international business, and that formed the beginning of international arbitration. So the Lex Data is so important because data now is perhaps the most contested asset in an international arbitration, and often in a domestic one, more than physical property, because people will say that the information is fake, that the use of AI has created deep fakes and unfair evidence, or they're going to say that their data privacy rules haven't been followed and therefore the arbitral award can't be enforceable. So there are four pillars. One is about who owns and controls the data produced in the process. And if you control the data, you have obligations under the GDPR. under Canadian law called PIPEDA, and under the Mexican law, under the Brazilian law. And so if you have somebody who straddles any of those things, you could have what's called co-control, that you can have people who are controlling data from more than one spot. You also have the problem of data confidentiality. How do the confidentiality rules under law fit into the confidentiality we have in an arbitration or a mediation? The third question is data integrity. And as you know, here in New York State, we have an obligation to now, every 2 years, to have had at least 1 hour of CLE on the issue of cybersecurity and data integrity. So what happens with this data? What happens if there's a breach? What are our obligations to report? How is that going to work? And the last piece, the one I think is going to end up at the end of the day being perhaps one of the most important for ADR, is equality of arms, data equality. Are there disparities in resources between the parties by having access? Some big firms have access to Harvey, a huge legally focused AI that isn't available to small firms. And will that disparate ability to access large level capacities in LLMs, that's not a graduate law degree, that's large language modules. Those are the ways that you get the information in, better data sets, better pattern recognition. Can that undermine procedural fairness? That's what we're trying to figure out. And so foundationally, what we want to understand is, what do we need to do? And so there are 6 things that I suggest practically that you want to do. And this is in the data part before we even get to the AI part. The first is you want to minimize what is unnecessary to be produced in data. We call data minimization. If you don't have to put somebody's birth date in, don't. If you need it, then you need to have it and you need to secure it. But if you can have the arbitration or mediation without having to disclose somebody's social, without having to disclose somebody's passport number, without having to put in personal privacy data or medical data, then try to avoid that. That's a very simple, straightforward way. The second thing is have protective orders ready and include what you want to do for processing of data, because you need to think about how the data is being scraped. Remember the fights that are going on between the New York Times and ChatGPT about scraping of data without permission? We have that with law firms all the time now. And we have clients that say, my privilege rights have been affected. So we need to think about that. The next piece is about the cross-border data transfer rules. That's the Lex Data in its simplest part. Can you transfer the data? Do you need to think about these things? Those are the issues. The fourth piece is provenance and chain of custody. Do I have the right to be able to have that data, and can I show an audit trail? So I know that I'm only using the data from this case, and I'm not bringing in other factors. I mean, we couldn't do that if we were having a different type of case. If data was coming in from another case that was confidential, and one party didn't know about it, there would be a foundational breach. But yet that can happen in AI without even knowing it. So that's why the AI transparency becomes so important. And that takes us to the arbitrator's own use. Foundationally, now, the only thing I can tell you is if arbitrators use AI, they should be keeping a log of what they're doing. Whether you're researching it or you're drafting procedural orders or just doing a flow chart of what's going on, keep a log. Identify when you used it, what the query was, what your output is, so that you can disclose it. Because foundationally, the parties have ever increasingly rights to know how their dispute was processed and to object if they think there's some bias or something that's unfair. I'm going to take the last piece here, the Lex Data, as a gap filler, and then I'm going to allow Professor Phillips to give you the next code. But so where national privacy law is unclear, the Lex Data principles are going to come from institutional best practices. That's where we're going to look at IBA rules, AAA guidance. There's an excellent guidance that comes every now and again from the New York City Bar. I sit on that committee, and they're thinking about how to deal with that. The ICC is starting to do AI standards as well. They are going to help fill the gap And we need that. But our institutions are laggards and our law are laggards. They don't lead the way, they follow. And things are changing so rapidly that we need to figure it out. So these 6 principles are here to help you fill the gap. And talking about filling the gap, maybe, Professor Phillips, you could give us the next code that we need to have.
I'm absolutely pleased to do that. Our second code is accountability. Accountability.
Thank
Go
you.
on ahead, Barry.
Okay, so there's a law. I tell everybody this is like a spicy enchilada, this talk, because we need to bring things together. So, privacy law doesn't pause at the door of the arbitral chamber. Privacy law comes in to international arbitration. We have that from the EU's GDPR, the General Data Protection Regulation. Okay, it's a privacy framework. We have one in Canada. We have one in California, the CCPA. And if you do investor state, ICSID now has a rule that talks about confidentiality, but didn't get to AI yet. But that has to be filled by the Lex data. So if you have confidentiality, we have it in many of our rules. AAA has confidentiality rules, for example, so do JAMS. We need to make sure that we keep privacy frameworks in there. So what are our risks? Well, let me give you some examples. So these are cases that have happened. So the first one is the Samsung case. So in this case, engineers put code to ChatGPT. So they had Samsung information, they put in the ChatGPT so it could use the AI and be smart. But the arbitrators who input confidential submissions to commercial AI face the exposure that Samsung had. And what happened in Samsung is by accident, they put in the new design codes for some chips. And now they lost the ability to have them as secret. They no longer were secret. They were relying on trade secrecy as their IP protection, and they lost it. What happens when AI tools anonymize and aggregate data? They combine deposition transcripts or travel records or financial data. So you need a protective order to ensure that you can re-identify the privacy and that people have to disclose it. Again, another risk, not by design, but by operation. So if you can't control the data stream and keep it protected, which we would always do in paper, which we would always do also when we had boxes where we would just put things in Dropbox or something like that. Here we're losing that control. We have issues about cloud jurisdiction. This is about processing of data, and that's how you start getting into the GDPR, because your data, unless you check a box, may not be processed in the US, it may be processed somewhere else. So you have to actually request that you process your data in the US if you want to make sure that you keep your framework. But what happens if you're processing your data in the US, but the data is being processed in California? All of a sudden, your arbitration in New York is going to be subject to California rules. And you weren't expecting that. So you got to think about how you maintain that control, how you put that together, how you keep jurisdictional control so you know which privacy laws and which AI laws are going to apply. And then the last one is one of the ones that now are increasingly common. What happens if the AI is training on your data? And you have 2 types of training. You have the data that you put in itself, and you may ring fence that. That means that you may pay extra, and it says, we will not learn on your data. But the AI could be learning on your questions, on your queries, on what you're asking. And then you lose confidentiality. And if you're an arbitrator and the questions that you're asking all of a sudden are no longer confidential, what type of problems does that bring? And if you're a lawyer and you're involved in the process and your litigation work product privilege is now compromised because the AI can learn on what you're asking, that's a big problem. So these are new questions that we never had to think about that we now have to think about. So what we need to do is understand how to deal with that. And I'm going to give you an absolute, here's an example, and I wrote a new paper on this. It's the Tenant Energy case. And this happened about 10 years ago. And it's the only recorded case, and it's a case where the arbitrators got it wrong. And so all you really need to know is that it's a case involving the feed-in tariff in Ontario, just north of New York State, and there's an international dispute. It's under the NAFTA. And the question here is, you have an arbitration panel. The panel has one arbitrator from the United States, one arbitrator from Singapore, and one arbitrator from the EU. And the arbitrator actually was from the UK, so it was still part of the EU when this case was going on. And the arbitrator from the EU had posted a GDPR notice saying that I'm subject to the GDPR. Everybody does that. They follow the same form. And the arbitration was being administered by the Permanent Court of Arbitration in The Hague. And what complicated it is that their data was being stored outside of The Hague. So here the tribunal was asked, do you have to follow GDPR rules for data privacy, even though the parties aren't from there? One party was from California. The other party was a government in Canada. And so the Canadians said, it can't apply because we're a government. And the tribunal said, we don't want it to apply because we think it's going to be onerous and difficult. But foundationally, what the tribunal did was issue a one-paragraph ruling. And that one ruling said, we are not going to follow the GDPR. The problem was the GDPR applied not because of the treaty, but because of who used the data, who was regulated. In other words, the EU regulated arbitrator, the fact that he's controlling or co-controlling information meant that the GDPR would apply. Similarly, the fact that there was an arbitration secretariat in the EU also meant that the GDPR would apply. Furthermore, Canada was involved. There was an entity in Canada, and it was covered by Canadian privacy law called PIPEDA. And it also applied and had the same types of obligations. So you had three different areas. All of them required a data privacy regime, but the tribunal said we're just not going to apply it. It's like saying we're not going to apply the law of gravity. We do not like it. Well, nobody likes it. It's like paying taxes. But it was a mandatory law. And it was even worse because the law of the arbitration was Ontario and Canada, Toronto in particular. So it meant that they were also in breach of the Lex Arbitri, and they were in breach of this new law. Because this law they got it wrong on three different ways. Wrong jurisdictional triggers, they ignored the Lex Arbitri, and they misplaced their compliance obligations. So the reason I give you this example is all described in the paper, is that you need to think now that jurisdiction arises from where the data can be as much as where the parties are and the subject matter. So the types of things, the type of concepts that we use for forum convenience, or the way we would establish where the Lex Arbitri should be if it hasn't been established, and we look at different ways of dealing with that. The ancestral organizing notes are very helpful to help us with that problem. None of that applies here. We have a new layer, a new level of having to think about it. So that was our problem with the 10 energy. We had to think about the right way. And the way we fix this is by saying that you put things into PO1. You talk about what you're going to expect. You identify and accept that privacy law may be an issue, and then you follow it. And the ICC and the New York City Bar have an excellent model order that can help you with this. And they have done a very good task force to be able to look at this. But it's already out of date. So I've suggested here, which we'll share out with you afterwards, the 5 different principles that you can take into your next AI-assisted hearing. That you can look at disclosure, you think about neutrality, you look and acknowledge, you accept the privacy law is going to be there, that you use protective orders to address AI, so you just don't ignore it. The best way is to focus on it. And then we want to think about, there are going to be gaps, and you as an arbitrator or mediator have to intermediate. You have to use your best judgment to figure it out. So I'll give you what I call sort of a framework, and it comes from another paper I wrote called The Algorithmic Empire. But the most important thing you really need to understand is that sovereignty follows data now. So that is the big switch that we need to deal with. The most important thing that we need to understand is that we now need to think about how data itself needs to be managed, just like we think about the lex arbitrary managing procedural issues. We now need to manage data issues. And similarly, there's going to be a law and set of regulations that manage AI. And the AI principles are going to focus in on risk. The data principles are going to follow where the data is. So that's our process. Our process is going to be the lex data, where the data goes, which can be hard to figure out, and the AI is going to be risk-based, based on what the AI is doing. And so that takes us to thinking about some of the cases, the things that everybody talks about in a cocktail party, and they start with hallucinations. So the first case everybody talked about is Mata and Avianca, and that's a case where counsel submitted, it's from the Southern District, ChatGPT generated citations. None of them were correct. All of them were fake. They all look good. They were all fake. And the court decided in 2023 that AI output can't be a source of law. You can't outsource to AI. You're responsible. And then in a later case that I didn't put in here, but I'll tell you about, which is the La Paglia versus Valve. In that case, the arbitrator told everybody that he wanted to go on a vacation to Galapagos, and so get ready, I'm going to try to get this out quickly because I'm leaving in 10 days. And then he took everything and put it into AI. He didn't disclose it, and there were errors. And so they went to court foundationally to say an arbitration done by AI is a bait and switch. We contracted for an arbitration by an arbitrator, not by a computer. And the court basically vacated the award, said that was not what was going to be there. It got decided eventually on some other grounds, but it finally did get decided. So it's a little messy, which is why I didn't put it out. But it's pretty clear now that you must disclose if you're using AI, and basically you have to get consent. And that takes us to the case of Shepard and Gillen. And this is from Cutter. And so here, a Cutter-based lawyer submitted fake AI citations, hallucinations. And the judge was very unhappy. Okay, the lawyer admitted before the judge that these were done inadvertently. And the judge said, we're not going to do that. And this was the first case that started with sanctions. So the hallucination problem is global. And your clients may very well be giving you information that's hallucinated as well. So now when you go to verify your own data, you got problems. But the minute you take it to a court, you as the counsel or you as the arbitrator are responsible. Because just what we talked about with the model legal opinion 512 from the ABA, the buck stops with you, your professional responsibility. And that, in fact, was the decision that I referenced at the beginning that just came out last month in Deutsche Bank and Latenier. Okay, that was the one with multiple AI fabricated citations in the mortgage dispute. And here, they also misrepresented the interpretation of cases. They overstated cases. It's a head note problem, right? But made worse. And so partial truth is just as dangerous as pure fabrication. So you have pure fabrication, you're going to be sanctioned. And if you misrepresent, you're going to be sanctioned because you have professional responsibility. And sanctions are appropriate. So how do you prevent that from happening? So you have guidance from the AAA, and they have a product that can help you that will review things. Okay, and they say every output has to be cross-referenced against primary sources. And then they give you a tool that can help. But you also have things from Westlaw and from Lexis AI. They have tools where you can upload material and check it. This gives what we call, the topic's called grounded reasoning. It says that it's going to give you only verified sources from closed databases, which are exactly what you get from Lexis and exactly what you get from Westlaw. And so you can use platforms that look only the primary law because you have that obligation. You have to verify every citation. Before we had Westlaw and before we had Lexis, you had to go to the library and you had to do it by hand. I remember those days, and we would check everything, and then we would shepardize by hand, and we would go through all types of things. And it was wonderful when we could shepardize electronically. It saved so much bother, but it was reliable. It didn't hallucinate. Our problem is that AI wants to use patterns to please us, and it's going to shortcut to get something there, and it looks good, but it's not good. And that's where the verification has to kick in. Professor Phillips, are we ready for the next code?
What I'd like to do is offer the next code in about 15 minutes, closer to the end of the program.
Okay,
so
my apologies.
Go on ahead. No problem.
I'm going to finish up and take us then to the questions, and then as we get to there, I'll let you do that, because I want to make sure that I can see, I don't know what the questions are in the chat, but I can see there's a lot of questions, so I want to make sure that we've got time. So let me just walk through our ethical obligations, okay? This really comes foundationally, the best place is ABA Opinion 512. It was done on generative AI in 2024. There are 3 things that you need to know: competence, confidentiality, and supervision. They're very, very simple. 6 obligations. They follow 3 principles. Basically, we're going to follow the same things and what they are is we verify, we protect, and we supervise. So, the first rule, technology competence is an ethical baseline. You have to deal with the competence because you have legal training. So you have to understand the benefits and the risks of AI, just like any tool that you would use. And that involves how it's trained, how it's scraped data from things, and the privacy law implications. So rule 1, competence, 1.1. Rule 2, rule 1.6, the second point, confidentiality. Putting privileged case data into open AI models is a breach of professional duty because it's like sharing it with the world. Confidential information must stay confidential. It can't train somebody else's model. This is the foundational principle of the Lex data. Okay? And the third thing is supervision. You, if you are an arbitrator, or you, if you are a lawyer, have to supervise AI like you would a junior associate or a clerk or a paralegal or an arbitration secretary. And there's a new case that came out last week where people are starting to talk about unauthorized practice of law by AI. That is the same thing about supervision. And the answer is that responsibility can never be outsourced. The tool produced it. That's a tool. But you are responsible as a legal professional, whether you are mediator or arbitrator or counsel. You're responsible for its compliance. You're responsible for compliance with privacy law. You're responsible for its compliance with the AI law, if that's there. But you're always responsible for the ethics, because we're a profession. It's not a job. It's a calling. We are a profession. And ethics remains the human anchor of digital justice. That's what I say to everybody in TechCred. Ethics are what we are responsible for. Ethics are why we're there. That's what the courts expect us to do. That's what arbitration tribunals expect us to do. That's what arbitration institutions expect us to do. And if you want to have enforceable awards, we need to show that the ethical issue has been there. So that then takes us to, how do we have fairness? Because ethics then takes to the question of fairness. And so, as I had hinted earlier, agentic AI, that's where AI can do things for you, is creating a new digital divide between the elite firms that have the best things and the individuals that may have no AI, no access. You can't even go over to the county law library or to the New York City bar and have access to Harvey. You only have access to Harvey if you're in a big firm. And so pro se clients, solo practitioners, small firms are at a severe disadvantage. And there's a disadvantage between having Harvey and not having Harvey, for sure. You have to work harder with it. So we need to think about that. And then we need to think about the risk, the ability. I give 3 tiers. The lowest risk on the use of AI is for administrative uses. Grammar formatting, spelling checking, scheduling. This is routine use. I do not believe you need to disclose that in general. You need to disclose, I'm going to use some AI. And I always would say what that's for. I'm going to use it for the following things, and timelines, for document indexing, translation, which is itself a little controversial. If you ask the translators, they say they get it wrong. So, but that would be what I say is the green tier. Then you have the blue tier, substantive assistance, legal research, document review, assistance in my draft. And that's not writing it, but tone or editing. Here, for sure, you have to disclose this to the parties because they can get it wrong. And the parties have a right to know. They have a right to know what shaped the procedural framework of their case. And so that is the difference. If you start using AI, you really have to disclose it. And there's nothing wrong with using it in this way, but you need to be able to keep checking it because you, whether you're counsel or you, whether you are arbitrator, are responsible. Then we have our third tier, high impact, the black box. This is the area that I suggest you stay away from. A good area is damages. You know, if you have a case and you have contested damages and you have different experts and they're fighting all the time about how they're making their models and what goes on, I know the desire is to go to AI and say, just give me an answer. But that's exactly the wrong thing. That's where you need to know all the different factors and you can question and examine it. And if you have outcomes that are being modeled, but you don't know why and how, that is exactly the type of thing that should not be done by AI. That should, when you may very well require your own neutral technical expert to be able to review that. And you might have to ask each of the experts, if that, or the parties counsel, did you use AI? What did you use? How did you use it? What factors did you put in? So not only do you need to know algorithmically what's there, the transparency that we don't have in America, but you get in Europe, but you also need to know what assumptions are being used and how they're being used. So you have 2 factors. It's very tricky. And in the EU, you could use the damages with disclosure, but you could never, ever, it's prohibited to decide credibility by using AI. Deciding who is more credible or who is truthful always is a human decision, a human function. And so that is really the key piece. And so that's really where, you know, I would take us through what we want to do. And you'll see in the CLE materials that I've given you different scenarios. We're not going to be able to talk about them, but I gave you different scenarios in the CLE materials I just set out here about what we would do. If we were in TechCred, we would be doing this over 3 days rather than doing this over 75 minutes. And so we have many more ways of being able to unpack this and to deal with it, and to have projects and assignments interactively as groups to go through this. But that's what we really sort of need to think about, the types of ways. But the first issue, scenario A, is about the black box in damages. So before we turn to the, well, I'll tell you what, we'll do the toolbox and the procedural order, and then Professor Phillips will give us the last of our codes, and we'll go to questions. But so what's your toolbox? It's got to be PO1, procedural order number 1. And what do you have to put in now? You must put in a standard AI clause. You have to put in a standard data privacy clause. You have to update your templates with all the things you put in about the parties and the timing and the representation, if you're going to have disclosure and how that's going to go and how discovery works and all those things. All the things we've always had in PO1, now you need to make sure that you deal with data privacy, the lex data, and you deal with AI, what I call the Lex AI. So that's the first thing. Two, you need to think about, is AI evidence acceptable and is it reliable? And to do that, we do an entire day talking about that in TechCred. So all I'll say is we follow a process of dealing with integrity of the data. We often use things called the blockchain to help us, and replication. We look at, can you replicate it? Can you get back there? In other words, in math, when I learned math, they used to say, show your work. So I don't just want the answer, I want you to show your work. And for AI, I need you to show your work. I need you to show it with evidence, especially now with the prevalence of deep fakes. And I need you to show it with your thinking on the use of AI. The third is what I call Lex Data Compliance Checklist. That's for arbitrators. What are you going to do? Well, minimize data, privacy, that you don't need all the data that we might have before. How can I restrict or reduce cross-border transfers? And if I am going to use it, do I need to have things? If there's stuff between the United States and the EU, you need to have special rules. If it's not that way, in other places they have exemptions, but in the US we don't. So we need to know about that. Have I updated my PO1 for AI processing, for data processing? Have I obtained the right types of consents so that I can use the data? These are the types of things that we talk about in TechCred in some length. These are the types of things that we all need to know today, because these are the issues, and they're all starting to percolate their way through. And then number 4 is what I call the ethics spotter, a guide for generative AI. And the best place to look, first of all, is going to be ABA Opinion 512, and in particular, also ABA Model Rules 1.1, 1.6, 5.3, and you can look if you like at 8.4. I didn't talk about it today because I want to save some time. But you need to look about these things so that you're going to make the right types of decisions, and you have to keep the responsibility. You can't outsource the responsibility, okay? The buck stops here. So the competency is an ethical obligation, it's not technical. AI doesn't replace judgment, it magnifies your responsibility. So if you're going to use it, you need to be ready for it. Confidentiality obligations exist independently of the arbitration confidentiality, and AI processing is not accepted, so you need to think about that. So that's why this Lex data is emerging. Privacy law, could be treaty, all those things. We need to think about that. And we saw that from that tenant energy case, that tribunals need to know how that goes. Peter, just give me 30 seconds more, and then we've got this. Disclosure strengthens enforceability and protects legitimacy. And that's really our thing, because you, as a professional, are responsible for every word in your submission, every data set in your evidence, whether it's generated by AI or not. The buck stops here. So that doesn't change. It's simply a little bit more difficult with the use of AI. Professor Phillips, give us our code, and then we should be able to go to the questions.
Well, let me give you, let me just pose a question or two for you first, okay?
Sure.
Is there a role for Ancetralon here? The concern that I'm hearing is that there's a pan-jurisdictional source of data, a pan-jurisdictional destination of certain data, and that there is a patchwork regulatory scheme that's developing that, and not just, as you put it, not just in cross-border arbitrations, but even in domestic arbitrations. There are different states, and there are the EU data laws could easily impact domestic proceedings. Is it too early to ask whether a convention might be forged so that uniformity can be brought in the same way that the New York Convention, brought some sort of uniform legal status to agreements to arbitrate and outcomes of arbitration. Are we going to eventually need something like that?
So let me answer this a slightly different way. First of all, I was the AAA representative at UNCITRAL for 4 years, and I attended all their meetings in New York and in Vienna, dutifully going on. And during that period, we got nothing resolved in 4 years, 8 sessions, going back and forth, because the process at UNCITRAL is glacial. And it's not that Uncentral's bad, Uncentral's good. It's just the international law process is very slow. The reason we got a New York Convention, which was a wonderful thing, is because the Geneva Convention from 1925 was so bad. It was the fact that we had a convention that was so bad, so hard to use, so disruptive to the process, so opposed to arbitration, that finally in 15 years, we were able to get the New York Convention, which has worked out unbelievably well. And then we had the model law, which made it easier. So the question here is, you start with disaster in international conventions to get the ability to get to good. And I know that sounds terrible. So yes, we have all the makings for an international convention, but it's more likely than not that we are going to be living in my working generation. I'm going to be living in a non-uncitral time. But for the young people that are following this, and for my students, they will have the benefit when they are more seasoned professionals to perhaps have a treaty. Because yes, we should have a treaty, but no, it's going to be very difficult to get one
Right.
for this to work. So that's our problem. Right outcome,
All right.
but difficult process.
Yeah. All right. I have another. You only mentioned this glancingly, but I think that it's a profound problem in this. You used the phrase equality of arms. Uh, it, it seems to me, and I say this in order for you to correct me. It seems to me that AI as a tool that some people have access to is not distinguishable from any other tool that in conflict resolution some people have access to and others don't. Some people can afford smart lawyers and some people can. Some people can afford access to arbitration and some people can. Some people have other sources that other people can. And it seems to me that's baked into dispute resolution. I sense from some of your remarks that there is a virtue in trying to intervene in that and try to create some sort of an equal level with respect to access to AI. And I wonder if you could flesh out why.
Sure. So, first of all, equality of arms is a foundational fairness principle of arbitration. And so the question is, if you can you as an arbitrator regulate what the parties use? In America, we are less likely to order that. In other countries, they're much more likely to order that. However, the foundational principle is something we see in our courts. And if and so the real answer is going to be, are there going to be tools? So for example, if there are tools that are available on Westlaw or on Lexis, nobody is going to order anybody else that be given access to something else. In other words, if you've got the basic tools, you can choose how you do things. But basically, if you're in the courts, we have public defenders. And when we have people that come in pro se, we tend to give them more of a break because they might not understand. And we explain things. We see this all the time with arbitrators or mediators that they explain to the unrepresented party much more to try to ensure that there's fairness. And that's what I'm trying to get to is that point. And I think that you're going to see decisions on that probably within the year coming out from, I think, the UK first, and maybe in Europe. And I think they're going to start percolating their way into the US. And I think what's going to happen is that Harvey is going to provide a mini version, mini me, mini Harvey, available for people who are ordered to do so by arbitrators. And they'll pay for it. So it's not that they're going to get it for free, but they'll have access to it. Because right now they can't have access. That's the difference. It's not that you can't pay to have access, you can't have it.
Yeah, it reminds me of Colin Rule and I were in China and we were given a tour of a court that had in the lobby of the courthouse uh, it's absolutely public access terminals where you could look up what your problem is and you would be
Right,
given lots of information about what the codes are and how much it
right.
costs. And
You can't
yeah,
do that for this type of AI. For the
no,
high level models, they won't allow you to do it. That's exactly what I'm talking about. So when you can start to go to a law library, a county law library or something, and have access, that problem goes away. Or if you have a way of dealing with it by way of buying something, that problem gets lessened very significantly. But when you can't do it, the problem presents. And I see that, a lot of my comments have been arbitration oriented, but I wrote a paper on mediation and AI and these issues for the ABA's year in review, and it's about to come out. I'm told that it will be out in a month. And it is entirely focused on the mediation side of this, because, of course, as we know, mediation is different. But the same obligations apply if you're using this to decide things. It's just how are you approaching this? But we have a little bit more leeway in mediation, of course. Now, Professor Phillips teaches mediation as an expert mediator, so he'll have a much better understanding intuitively of what I'm saying. Because I had to stretch a little bit my mediation chops. I do much less on mediation and much more on arbitration. But I wanted to make sure that we got the whole ADR community in here because we
yeah,
use different
absolutely.
techniques, but the responsibility doesn't change. That's what I'm saying.
All right. Well, look, this has really been pretty exciting stuff. The
I've left
one
the
for all
TechCred
the
Substack here so people can get that. Look,
all
I
right.
appreciate there's a lot of stuff that we've covered here because we've opened up a big world. If you want to understand it in a much easier way, we do it in 3 days. And it's lovely and it's wonderful, and you walk away knowing a lot. It's hard to do it in 75 minutes, but this gives you an understanding of the questions and of your key core responsibility. Your core responsibility is that you have to apply that professional responsibility. It's the most important thing.
That's which is my lead for our third and final code. Our third and final code is responsibility. It's the theme that ran through the entire presentation, and it's one that we can never be reminded of enough, particularly in an environment of uncertainty and innovation. One thing that doesn't change, as Barry pointed out, we're responsible for our own work. Barry, thank you so much for everything that you've done and everything that you've helped New York Law School to accomplish. And thank you, everybody, for joining us on this. Uh, I hope that I get to see everybody at the school in April when we do the cutting edge on the 21st. And best of luck to everybody. Barry, thank you again.
Thank you and the center for such a wonderful opportunity. I just want to remind everybody that we can do this in bite-sized pieces, but the future is here now. So we can't do an ostrich. It's much better to just get in there and to know the right things and to follow our heart, follow the professional responsibility of our profession. It really takes us 9/10 of the way. So thank you for the opportunity to talk about this and such a wonderful program that you run for the community here at the New York Law School. Thank you for letting me come and join you today. Thanks, everyone.